Hello and welcome to another online lecture series of the Jean Monnet Network on Enforcement of EU Law. My name is Valeria Caforio and I am a PhD student at Bocconi University in Milan. Today's lecture will be about the public enforcement of EU competition law, that is the enforcement of Articles 101 and 102 of the Treaty on the Functioning of the European Union, respectively on anti-competitive agreements and abuses of dominance by national competition authorities. The lecture is titled Decentralized Enforcement of EU Competition Law, the Good, the Bad and the Ugly. In this lecture, I will begin by highlighting what has been achieved in recent years, so the good. Then I will provide an overview of the current landscape, the bad, and finally I will address the issues and forthcoming challenges that EU competition law enforcement will face in the years ahead, what we can define as maybe the ugly. So when we talk about EU competition law enforcement, first of all, we must distinguish between a before and a after 2003. Indeed, before 2003, we had a very centralized system in which the Commission was the only institution competent to apply Articles 101 and 102 of the treaty. On the other hand, national competition authorities were competent to apply their national competition laws, although some of them could also apply parts of the EU antitrust provisions. In addition, there was also a kind of mandatory notification to the Commission for potentially restrictive agreements. In 2003, with Regulation 1 of 2003, we had a sort of Copernican revolution in the public enforcement system of EU competition law. Indeed, there was a shift from this centralized to a decentralized system, which attributed the competence also to national competition authorities to apply the treaty provisions concerning agreements and abuses of dominant position. In particular, according to this system, national competition authorities can apply EU competition law along with their national legislation, but according to Article 3 of the regulation, they must apply Articles 101 and 102 when a particular conduct is capable of affecting trade between member states. So, the requirement of this potential impact of a conduct on trade between member states makes the application of Articles 101 and 102 of the treaty by national competition authorities mandatory. The regulation also abolished the ex-ante notification system on agreements and the monopoly of the Commission on the application of Article 101, paragraph 3 of the treaty, which provides an exemption for some agreements from the application of Article 101. According to this system, national competition authorities can apply competition law even in important cases and on an almost equal footing with the Commission, which nonetheless retains the power to take over cases. The main objectives of the reform were two. First, to reduce the Commission's burden in order to make it possible for it to focus on the most important cases, such as, for example, hardcore restrictions. And two, to increase the number of bodies to combat illegal behavior by applying EU competition law. In the end, we can say that Regulation 1 of 2003 has succeeded in these objectives. It has established a flexible and capillary enforcement system which provides with a few exceptions, a good allocation of the cases between the Commission and national competition authorities. This included the creation of a network of national competition authorities and the Commission for both the allocation of cases and the discussion of the most important competition issues in each case. Thanks to the reform, the Commission was able to focus on the most important cases, and the total number of decisions adopted under Articles 101 and 102 was more than 10 times higher than before. However, significant problems were still persisting. The establishment of national competition authorities to enforce Articles 101 and 102 of the treaty was shaped by national competition laws, and it appeared very different in terms of both resources and independence, especially from governments. In particular, many national competition authorities were unable to conduct proceedings against certain industry or sectors due, for example, to lack of resources or officials, or because of the mentioned links with the state or the government. In addition, many national competition authorities lacked important investigative powers, even the most efficient ones, such as the German Competition Authority. And furthermore, some national competition authorities did not have sufficiently strong decision-making and corrective powers. In the end, this translated into a lack of uniformity and effectiveness in the enforcement of EU competition law. However, the so-called ECN Plus Directive of 2019 came to solve some of these issues. The idea behind this piece of legislation is to create a level playing field in terms of establishment and powers of national competition authorities charged with the enforcement of Articles 101 and 102, and to create the conditions to strengthen cooperation between national competition authorities during the investigation and enforcement phases. For example, the collection of fines from companies which are located in different member states. The ECN Plus Directive aims to provide a minimum standard for the establishment of authorities, their independence, their resources, and their powers. In other words, any national competition authority should be able to apply EU law effectively and in a similar way to avoid that companies can take advantage of differences in the configuration of national competition authorities to carry out a kind of forum shopping. The effect of the directive is more generally to increase the level of deterrence by attributing more investigative powers, by imposing stricter remedies, more fines, and by providing aligned leniency programs. So against this background, moving to the bad, some challenges remain open in the current enforcement system of antitrust law. The first concerns the fact that national competition authorities, despite the mechanism that we have described, could still be tempted to apply their national competition laws, even to cases that should be dealt with under Articles 101 and 102 of the treaty. This is due mainly to the ambiguity of the criterion that we have mentioned of the potential effect on trade between member states. A possible solution could be to add a more objective criterion, for example, based on turnover, market share, or to establish a mandatory application of EU competition rules in specific cases. Furthermore, while there has been much convergence between EU law and national legislation in terms of general provision, procedural rules still differ among the member states. The second one is that there has been almost no harmonization between the decision-making stage of a national competition authority. In particular, each member state appears to have its own jurisdiction, which is particularly anchored to national principles in the interpretation of the legislation. Therefore, in simple words, standardization is insufficient if then national courts disregards EU principle and rules. We can think, as an example, to the Italian jurisdiction, where the decisions taken by national competition authorities annulled by the administrative court amount to 60%. Furthermore, while there are actually instruments that should ensure the uniform application of EU law, mainly preliminary rulings on the interpretation and validity of EU law, national courts barely resort to them. Finally, new challenges for competition law enforcement arise in digital markets, especially following the entry into force of the Digital Markets Act. The Digital Markets Act differs from antitrust law. It is a piece of regulation that aims to establish fair and competitive markets in the digital sector. The question is, are we dealing with an ugly? And this is actually an open question. What is known is that the two approaches are different. On the one hand, antitrust enforcement focuses on specific markets. It intervenes after the occurrence of restrictive or abusive practices, and it involves time-consuming procedures. In contrast, the Digital Markets Act aims to proactively minimize the negative structural effects of unfair practices before they happen, while still allowing the possibility of subsequent intervention by EU or national competition law enforcement. Therefore, we could ask how the role of the Commission in applying both the Digital Markets Act and EU competition law will be shaped, and what will be instead, if any, the role of national competition authorities in applying the DMA. Furthermore, given that the DMA could in part overlap with competition law, we can think, for example, of the famous self-preferencing conduct. We could also wonder what will be the residual spaces of antitrust enforcement and if there will be a risk of bis in idem in the application of these two pieces of legislation. However, as some authors have suggested, we can identify some positive direction lines. In particular, we should see ex ante and ex post intervention as complementary and not as substitutes. So the combination of these ex ante and ex post tools offers an opportunity to reconcile different objectives such as timeliness, predictability, and harmonization, which are typical of ex ante regulation, with flexibility, adaptability to changing context, which are characteristics of ex post intervention. Furthermore, the presence of multiple tools can allow the European Commission and national competition authorities to pick the best available instrument in each specific case, which could be particularly valuable in complex scenarios which are typical of the digital sectors. Of course, this will require strong and effective cooperation among all the public entities involved. Indeed, cooperation helps to select the best tool and to exploit the complementarities between these tools, increasing effectiveness. So in conclusion, we can say that despite some ongoing challenges and unresolved matters in the decentralized enforcement of EU competition law, the current scenario leans towards a positive assessment. As we have demonstrated, Regulation 1 of 2003 has successfully established a robust and widespread enforcement system which empowers the Commission to prioritize significant cases while enabling national competition authorities to effectively address anti-competitive practices through the application of Articles 101 and 102 of the Treaty. So thank you for joining, thank you for your attention, and if you have any question, don't hesitate to contact me. Goodbye.